Welcome class. It's a new dawn. So KASNEB, this is CPA, CS, CCP, foundation level, introduction to law and governance. I'm very pleased to bring to you this paper, and we'll be discussing the whole of it. This paper was done in August 2022, so it's still fresh, but of course our intention is to help you revise and work with us. So we'll go straight to question 1. We'll start with question 1 and then move on as with continue the rest of the questions. So to our question 1, in relation to the classification of law, distinguish between municipal law and international law. Municipal law and international law. So we'll start right there and then move on to that question. So in relation to the classification of law, distinguish between municipal law and international law. Now, municipal law, these are basically we can call them the domestic laws that are basically going within the boundaries of a nation, So these are laws that are formulated within the boundaries of a nation. So we are talking about a sovereign nation here, and which comes up with laws. A sovereign nation comes up with laws that will govern selected territories within its boundaries. Selected territories, cities, or something like that within its defined boundary. So that qualifies to be municipal law. Domestic laws that are formulated within the boundaries of a nation, and we are talking about a sovereign nation. So laws that are formulated within a sovereign nation to govern basically we talk of the relationship between individuals and the administrative section within certain territories or cities. It's also called an internal law. So internal law within a certain sovereign state, we have laws that govern basically the cities or certain defined territories within a sovereign nation. It's very important that we talk about within a sovereign nation, because that's the distinguishing factor between a municipal law and international law. When we talk about international law, you realize that we are not talking about within the boundaries of a certain state. Instead, we are talking about the legal relationship between one state and the other. So this is international law, is about the laws that govern the relationship between one sovereign state and the other, one sovereign state and the other. So we are talking about two countries. We are talking about more countries than just one, and basically their relationship, the laws which will govern their relationship, that's what we call the international law. So this has to be laws that govern two different countries. And when we talk about two different countries that are internationally recognized as being sovereign from each other. So sovereign means that every country has powers to run itself. So the relationship between these different states is what, and the law that governs them is what we call the international law. So domestic is within the boundaries of a sovereign state, and basically it covers the cities. It has the jurisdiction over the cities or territories within a certain nation. And then international is about one sovereign state and the other sovereign state, the laws that govern that relationship. I hope that is very clear. It should be able to give you 4 marks. Maybe if we just talk about the examples. Here we are talking about Kenya and Uganda because all these are sovereign states. And then here, under this municipal law, we are talking about cities. We have Eldoret, which is almost becoming a city in Kenya. But let's just talk about Mombasa City and Nairobi City. You know, the laws that govern those territories. Those are 2 different territories which are recognized as being, independent within the country. So each can have its own different laws to govern that particular defined territory, but within a state. So that's what we mean by municipal law. So that should be able to give you 4 marks. Let's look at the second item here. The difference between substantive law and procedural law. Substantive law and procedural law. Now, substantive law, that is the content, the law itself. The procedural law is about the methodology. I think just if somebody might ask you to give a very quick summary of the difference between substantive and procedural law. Procedural law, just from the word procedure, we are talking about the methodology, the how. So we are talking about the how. We are talking about the steps. We are talking about the procedures. No, the procedures, that's from the word procedural. The procedures that are going to be followed to arrive at a decision. That is the methodology. Procedural law, the methodology that we are going to use to arrive at the final destination. Is it lawful? Then substantive, we are talking about the law itself. The law itself that is going to decide whether you are going to win on a certain case or not. The substance of the law, basically where we are going to get the reasoning for the judgment. That is what we call substantive law. The reason for what is going to aid or to help the judge come up with a judgment. There must be that substance, the real content that will help guide the judge towards decision making. So these substantive laws are basically the rules that will guide the judge on how to make a decision. I have some few write-ups here which I'll just, for the sake of it, to help you get the point home. So substantive laws, rights and obligations that govern people and organizations. They are the laws of general and specific application, and it's also can also be defined, this substantive law, as the independent set of law, that decide the fate of a case, I've just said this is the reason behind the judgment. So they will basically guide or give the judges the reason on why they are going to decide the way they are going to decide that case. And that's basically what this statement is saying, that is the independent set of laws that will decide the fate of a case. This is where the judge will find his, the platform or the base of whatever his judgment is going to be on a certain issue or case that is before him. So it when you come to procedural law, I think this one is just exhausting. That it's the methodology. These are the steps that are going to be followed, especially to make sure that we finally give a very good judgment. So this is the substance of the law. These are the procedures that we are going to follow, the methodology. I think the key word here that you are supposed to use in that distinction is the methodology. And we are talking about the how, the steps, and possibly the procedures that are going to be used to make sure that we arrive at the right decision. The definition I have here is that it sets out where, when, how claims are made and how the case is handled before the case. No, where, when, how, and basically how the case is handled before the court. This is the methodology. The methodology to be followed when we are talking about undergoing that claim process. If you are talking about a claim on the legal suit process, it's basically the steps to be followed to prosecute or to defend. It's about the due process. Let's just call it the due process, and the process should be as good as the law itself. I think this is a very good summary. Substantive law, we've said those are the rules that will guide the judgment or that will inform the judgment and will help decide the fate of the case. And then the procedural law is the methodology or the due process to be followed in the process of trying to possibly get your right or whatever it is that you are seeking for in the court of law. The methodology or the process to be followed, to be adhered to achieve the final expectation that you are seeking in the court of law. So let's move to the next item. Distinguish between the remedies available in civil law. Distinguish the remedies available in civil law and those available in criminal law. Now, I hope we understand that in civil law, we know the parties involved are the plaintiff and the defendant. Plaintiff and the defendant. And then criminal law, we talk about the prosecutor. The prosecutor and, of course, the other party who is involved. But basically it is the prosecutor who is charged with the responsibility of proving beyond doubt that the other party is guilty. So the prosecutor has the responsibility of proving before the court of law that the other party is guilty beyond doubt. Proving beyond doubt that the other party is guilty. This other side, it's the plaintiff that has the responsibility of proving that the other party, proving that the defendant is liable, not necessarily beyond doubt. You see, that's the difference. So plaintiff has the responsibility of proving that the defendant is liable so that he can now win the remedies which are available in civil law. But when we talk about criminal law, the prosecutor, who basically represents the government, because it's a criminal case, the criminal case is normally against the government. So the prosecutor has the responsibility of proving beyond doubt. It has to be beyond doubt, which is not the case here. This side, you really don't have to prove beyond doubt. So long as you can show that the defendant is liable, then you are eligible for the remedies that are available for civil law. But when you talk about criminal law, you have to prove beyond doubt that the other party is guilty, and once it's proved that he is guilty, then the remedies that are available include things like fines. We talk of penalties. We have fines. We have penalties. We have imprisonment. We have community service or service to the community. We have community supervision. There are quite a number. Community supervision. These are some of the remedies. House arrest. It's also one of the. All these are some of the remedies when the case goes. The case is successful. Then on the other side, when we talk about civil laws, the remedies available now include things like damages, where you pay to the extent of the loss suffered by the plaintiff, and then we have rescission, where you simply refuse to continue the contract. Then we have things like specific performance, awarded by the court, especially where the services of the services are key or are unique. We also talk of things like injunction, stopping the act from going on. We have things like quantum merit. That's also one of the remedies available for civil laws. And we also have, I think these ones can work. These are the major remedies, especially for breach of contract, which is very common when you talk about civil law. So I think these are enough. Distinguish the remedies available in civil law and those available in criminal law. These are some of the remedies available in criminal law. These are some of the remedies available in civil law. Damages, rescission, you to stop, to basically not continue with the contract. Specific performance, that is the court instructing the other party to actually do what he promised to do. Injunction, to stop the other party from doing what he intends to do. Quantum merit, as much as is earned, to basically get to the extent where the court orders the other party to pay to the extent of the services he possibly enjoyed. So you might want to get the definition, and maybe that will also be a platform for us. It might be another question to come. So let's not go there. Instead, for now, we have answered the question. We are supposed to distinguish the remedies available in civil law and those available in criminal law. These are the remedies available in civil law. These are the remedies available in criminal law. Fines, penalties, imprisonment in the Kenyan jails, the jail, serving the jail term, community service where you serve the community, community supervision, they check on you, you as fellow community people, house arrest where you are not supposed to get outside a certain vicinity area. So that will give you 4 marks. I think we've gone more than expected of us. Pick any 4 and you'll be good to go. So let's move to item C. State 8 sources of law identified by the Judicature Act. State 8 sources of law identified by the Judicature Act. Number 1, we have the Constitution. It is the supreme. We are only supposed to state, so we will state. Constitution, the supreme source of law in any country. And in Kenya specifically, it is the Constitution that was promulgated in 2010. That is the supreme source of law in Kenya. But any country will also have the Constitution as the supreme source of law. Then we have Act of Parliament, or what is commonly referred to as the statutory law. These are laws that are made in the parliament by the members of parliament who are representatives of the people. Then we have the delegated laws. Legislative is also this one can also be called legislative from the word legislature. So then we have the delegated laws. And delegated laws, these are laws that are these are other parties who have been basically given power by the parliament or act of parliament to come up with laws on behalf of the parliament. The parliament has later on to approve before they can become laws. So delegated laws, the parliament gives powers to other bodies or people to come up with laws on their behalf. It's also called delegated legislature. So it is the law, especially when you talk about professional bodies like ISPAC, like IHRM. In most cases, these ones are involved or are invited by the by the parliament to make laws that that are professional and require expert advice. Then we have the English common law, and I think we can group this and the doctrines of equity. These ones were applied in England, and we still borrow a lot from them. The English common law and doctrine of equity. Very important. It brings about those things that are very crucial, and basically that will ensure fairness in the eyes of law. So let's not go further because we're only supposed to state, but this is applicable in Kenya to the extent that they don't go against the constitution of the land. Then we have the customary law. Customary law. These are laws that are the traditional, that also try to uplift the traditional way of things. So the traditional laws, the laws that have been observed by a certain group of people, and they are accepted within that group of people, can also be used in the court of law. They are identified as a source of law in the Judicature Act. So customary laws, these are laws that are professed by a certain group of people, society or something. And then we have the Islamic laws. Islamic laws, that the Islamic religious group, and even they have their court, which is called Qadis courts. Qadis courts to enforce these laws that are professed by the Islamic religion. So we have Islamic laws, which are also a source of law in Kenya. Then we have the judicial precedents. Judicial precedents. These are from the case laws. Case laws, and basically they are binding. If a case has been decided in a certain way in a court of higher ranking, the judgment will be binding on a court of lower ranking. And so that case law can be used to pass a judgment in a lower ranking or even same level. So how many are these? 4, 7. We still have 1 to go. I think the last one that we can talk about are the general rules of international law. General rules of international law, basically governing the relationship between one sovereign state and the other sovereign state. So these are 8 sources of law that are identified by the Judicature Act. I think we might be having another question or another platform where we possibly will be required to discuss them. So in that case, we will go into detail. Otherwise, you can also check on join our platform. We have our school center where we do the online teaching, and you can get a very good explanation of all these sources of law. Just click on online platform and we'll be there. Thank you. Let's meet in the next question.